Hi, this is Curt and welcome to another edition of Fire Law Roundup. It's interesting on a legal perspective. I'm not sure. I think the headlines and some of the things that I've seen in the media about it could lead the average firefighter not to fully understand what's going on here. But bottom line is we have in New York City, you have an EMS system that is, I believe right now, mostly FDNY employees. But in addition, there are some hospital-based EMS units that do respond. They're dispatched on EMS runs, and they do transports under the overall umbrella of the FDNY. And that's important because the medical control is overseen by FDNY doctors. FDNY has its own doctors, and they will make those med control decisions. So we have a situation where a particular individual was having, I guess, a seizure, and the medics responded, and they, what was the medication? Oh, Versed. They gave
Versed, Valium. It's just Valium. It's to stop a seizure.
Right. And he ended up coding. And the question was, there's a couple of questions. Number one, was the decision to administer Versed proper? So that is why FDNY was sued, because the medical control of FDNY made the decision to administer the Versed. The second part of it is whether or not they properly resuscitated him, properly ventilated, properly kept the airway, and properly handled it once he had flatlined. And that's really on the EMS unit, who is basically employees of New York Presbyterian Hospital. So now we got a hospital-based EMS unit. So the question here was whether or not FDNY in the city of New York was going to be potentially held liable. This was a motion to dismiss. The city said, look, we have immunity protection. That was a discretionary act. It's covered under immunity in New York State, and every state is going to be a little bit different as far as that goes, but essentially this was an immunized type of decision, and therefore FDNY should be dismissed from the case. And the court agreed. The court said, yep, that this was, and you can read the language in there, but the physician's actions were plainly part of a municipal emergency response system. It was a female doctor. She was employed by the city's fire department. She acted only upon the request of frontline paramedics who were responding to a 911 call. She assessed the decedent in a pre-hospital setting. She worked within the protocols that had been set by the advisory committee. Her ability to provide services was limited to the services available to the medics. In light of the foregoing, we do not consider whether or not the city has established that the physician did not depart from the standard of care. In other words, it's really irrelevant whether or not she was negligent or not, that she has immunity. And we'll go back to that first sentence here. If you go back to the question, the Supreme Court correctly determined that the city was immune from the plaintiff's claim because the city's physician was performing a governmental function when she authorized the paramedics to administer the sedative. So again, the case is going to proceed against New York Presbyterian Hospital and that system, but FDNY has been dismissed out of the case because the city and the doctor have immunity.
And this is kind of where we were going in the last one, where we say, well, you slipped it, you dropped a patient, right? That we were surprised that they would just settle. We don't know the reasons behind it, as the city said in that case, it's worth it, or the best interest of the city to do so. But here you have the opposite, right? You're saying, no, we've got governmental immunity and we're going to use it, and they do. And it's a real shield. And I'll tell you that I met with a bunch of prospective clients the other day, and they're talking about, should we go from a private fire department to a fire district fire department, and is it better or is it worse? And I said, listen, you've got no immunities now, but look at all the immunities you get later. And so there is a benefit to being governmental, not private, and this is, you get to see it. But that's a good case, and it really was the right case. I do want to point out, though, and you read the language I was going to go to, the courts use facts to do a couple of things. Here, I believe they're using facts to disassociate themselves with other cases that would say, well, wait a minute, standard of care, you could have been reckless, you could have been, right? And they're saying, no, under these very specific instances, governmental immunity applies, and they go through some of the important facts. I like that because when you are a lawyer on that side, or, in a later case, either on that side or on the other side, you're able to point to the facts and say, these are similar, these are not. As opposed to normally when you read a court case, you don't know what the facts were all the time. So here it was good that the appellate division did a good job. The first department's although I've never won there, the first department's a fairly sharp sometimes appellate division. I'll say sometimes, but they got this one right. Okay.